Alright, Title 30, U.S. Standard Code, Chapter 29, Oil, Gas, Royalty, Management from Title 30, Minerals, Land, and Mining. Chapter 29, Zero Oil, Gas Management, 1701, Congressional Statement of Finding Purpose, 1702, Definition. Subchapter 1, Federal Royalty Management and Enforcement, Duties of Secretary, Duties of Leasers, Operators, Motor Vehicle Transport, Required Reporting, Record Keeping, Deposit Royalty Funds, Indian Accounts, Explanation points, liability, bonding, hearings and investigation, inspections, civil penalties, criminal penalties, applicable civil penalties, various federal, inland, outer continental shelf, royalty terms, conditions, interest, penalties, adjustment, refunds, injunctions, specific enforcement authorities, rewards, secretarial, delegate, states, action, limitations, period assessments, or all alternatives for marginal properties, royalties on extracted methane. Subchapter 2, State and Indian Tribes, Application Chapter, Application Subchapters, Leases of lands of 3 miles seaward, boundaries of coastal states, cooperative agreements, information, state suits under federal law, delegation royalty, collection related activities, shared civil penalties. Subchapter 3, General Provisions, Secretarial Authority, Reports, relation to others, funding, statute limitations, expanding royalty, obligations, variability, usual royalty and revenue by minerals management service and fees and charges. Alright, 1701, Congressional Statement defining its purpose. Congression finds that the Secretary of the Interior should enforce effectively uniformly existing regulation of the mineral leasing laws, provide inspection procedures, activities on lease sites on federal Indian lands, system accounting with respect to royalties, other payments due owing on oil and gas produced for such lease sites, Archaea inadequate. Essential for the Secretary to initiate, proceed with an improved method of accounting such royalties payments to provide routine inspection activities related to production of oil and gas on such lease sites. Secretary should aggressively carry out on his trust responsibility administration Indian oil and gas. Because the purpose of the sheriff to clarify, reaffirm, expand, define responsibility obligations of the leasers, operators, and other persons involved with the transportation or sale of oil and gas from federal Indian lands from the outer continental shelf. 2, to clarify, reaffirm, expand on the defined authorities' responsibility, security of the interior, implement, maintain oil management system for oil and gas leases of federal lands, Indian lands, and other continental shelves. 3, to acquire development enforcement practices, ensure prompt, proper collection, disbursement. Oh, yeah. Alright, it's the purpose of this chapter to clarify, reaffirm, expand, define responsibility, obligation, leasers, operators, other persons involved with the transport, sale, oil, gas from federal Indian lands, outer continental shelf. Clarify, reaffirm, expand, and define authorities responsible of the Secretary of the Interior of the implement, maintain oil management system of oil and gas leases on federal lands, Indian lands of the outer continental shelf. To acquire development enforcement practices, ensure prompt, proper collection, disbursement, oil and gas revenues owed to the United States Indian leases, and through ensuring the benefits of the states. Fulfill trust responsibility of the United States for administration of Indian oil, gas resources, and effectively utilize capabilities of state Indian tribes to develop and maintain efficient and effective federal royalty management system. Section 1702, definition, purpose of the chapter. Federal land means all land interests for the land owned by the United States subject to mineral leasing laws, include mineral resources, mineral estates, reserved to the United States conveyance for the service of the non-mineral estate. Indian allotter means an Indian whom land or interest in the land is held in trust by the United States or holds of the subject of federal restriction against alienation. Indian lands means any lands, interest lands of the Indian tribe, Indian allotter, held in trust by the United States, of which subject for the federal restriction against alienation, or which has been administered by the United States pursuant to Section 1613G of Title 43, including mineral resources, mineral estates, reserved to Indian tribes or Indian allotters, conveyed conveyancing for the service of or non-mineral estates, except those such as does not include any land subject provisions. Section 3 Act of June 28, 1906. Indian tribe means Indian tribe, band, nation, pueblo, community, rancherie, colony, any other group of Indians, including Medalla Cantada, Indian community of a net Indian island reserve for which any lines interest land is held by the United States in trust with subject to federal restriction against alienation, which is administered by the United States pursuant to Section 1613 G, 43. The lease means any contract or profit share arrangement, joint venture, or other agreement issued or approved by the United States under mineral leasing laws for the authorized exploration, removal, or gas leases site. Means any land submerged, including surface or served mineral sites on which exploration, extraction, removal of oil and gas is authorized pursuant to the lease. A leaser is any person to whom the United States issues an oil gas lease, or any person to whom operating rights to the lease have been assigned. Mineral leasing law means a federal administrated by a secretary authorizing disposition on the lease of oil or gas. Oil and gas means oil and gas originating or allocated to the Outer Continental Shelf, federal or Indian lands. Outer Continental Shelf means the same meaning as provided in Outer Continental Shelf Lands Act and Public Law 95-372. Operator means any person, including the leaser, which control of which manages on an oil gas lease sites on federal Indian lands or Outer Continental Shelf. Person means individual, firm, corporation, association, partnership, consortium, joint venture. Production means the activities taken for a removal of oil and gas, including such removal, field operations, transfer of oil and gas from off the lease site, operating, monitoring, maintenance, and work over drilling. Royalty means any payment based on a value of volume of production which is due to the United States or Indian tribe, Indian allotment on production oil gas from the United States, from Outer Continental Shelf, federal Indian lands, and a minimum royalty owed to the United States or Indian tribe, Indian allotment under provisions of the lease. Secretary means Secretary Interior designee. State means several state unions, District Columbia, Puerto Rico, the territories possessing the United States, and the trust territories of the Pacific Islands. Adjustment means the amendment previously filed, reported obligation, additional payment of credit, if any, applicable thereto, rectify underpayment, overpayment of obligation. Administrative proceeding means Department of Interior agency process in which demand, decision, or order issued by the Secretary or delegated state is subject to appeal, has appealed. Assessment means any fee, charge, levied, imposed by the Secretary or delegated state other than the principal amount of any royalty, minimum royalty, rental, bonus, net profit share, or proceed of sale, any interest, any civil or criminal penalty. Covenants means respect judicial proceeding, service of complaint, petition, court claim, cross claim, other pleading, seeking affirmation, relief, seeking credit, or recoupment movement, provided that the Secretary commencement as judicial proceedings against the designee. Secretary shall give notice of commencement of the leaser who designated for the designee, with the Secretary not required to give notice for the leaser for the who may be liable to pursuant Section 1712A of the stable obligation of this subject of judicial proceeding, or with respect to a demand recipient, Secretary, delegated state, leaser to his designee, with the written notice of the leaser who designated the designee of the demand. 21. Credit means application of the overemployment in whole and part against the obligation. Overpayment. Credit means the application of overpayment in whole or in part against the obligation which has become due to discharge, cancel, reduction, obligation. Delegated state means a state which, pursuant to agreements under Section 1735 of the title, performs authority, duty, responsible activities of the Secretary. 23. Demands any order issued by a Secretary applicable to delegated state, leaser, or designee, which is noticed for the leaser or designated by the designee, has reasonable basis to conclude that the obligation amount of the demand is doing and owing, or separate written request the leaser or the designee asserts the obligation due to the leaser or its designee, provide a reasonable basis conclude that the obligation in the amount of the demand is due to owing, but does not mean any royalty, production report, information contained therein required by the Secretary of Delegated State. 24. Designee means the person designated leaser pursuant to Section 1712A of the title such of the written designation effective with the date such designation received secretary remaining in effect until the secretary receives notice in writing that the designation modified or terminated obligation any duty of the secretary if applicable delegated state to take oil, gas, royalty in kind or pay refund offset credit monies included but not limited to a principal amount of any royalty, minimum royalty, rental bonus, net profit share, proceed of sale, or any interest and any duty of the leaser or designee as in subsection provision section 1712A of this title, deliver oil, gas, and royalty in kind, pay offset credit monies include but not limited to principal amount of any royalty, minimum royalty, rental, bonus, net profit, share, proceeds, sales, any interest, any penalty, and assessment which arises relates to the lease administered by the secretary for any mineral leasing or related to the file to the exploration, production, development, oil, gas, and federal lanes or outer continental shelf in order to pay the mains. A written order issuing secretary applicable to delegated state leaser or his designee with a notice of the leaser with the designee wishes so specifically define a quantified obligation claim to be due. Specifically identifies obligation by a lease with the production monthly monetary amount of such obligation claim to due or order to be paid as well as the reason such obligation complained to do, but such terms does not include any other communication action or by or on the behalf of secretary delegated state. 27. Overpayment means a payment on the lease or the designee in excess of the amount legally required to be paid on. Obligation includes a portion of any estimated payment for a production month that is excess of the royalties due for that month. Payment means satisfaction, whole and part of obligation. Penalty means a statutorily authorized civil fine levied imposed for violation of the chapter. Any mineral leasing law term provisions lease administered by the secretary. Refund means return overpayment. State concern means with respect to the lease state which received the portion of the royalties or other payments under mineral leasing law such lease. Underpayment means any payment or non-payment of the leaser of the designee that is less than the amount legally required to paid on the obligation. The United States meaning the United States government, any department, agency, and instrumentality thereof, several state, district, Columbia, and territories of the United States. Section 1711, Duties of the Secretary. 8. Establish inspection, collection, accounting of the auditing system. Secretary establish comprehensive inspection, collection, fiscal service, and production accounting auditing system. Provide capability accurately determine oil, gas, royalties, interest, fine, penalties, fees, deposits, other payments owed, and to collect account such amounts in a timely manner. Annual inspection and lease sites training. Secretary shall establish to ensure that the authorized, properly identified representative of the secretary will inspect at least once annually each lease site expected to produce significant quantities of oil and gas in any year which history of non-compliance with applicable provisional laws and regulation, and establish, maintain adequate programs, provide for the training of all such authorized representatives in method, techniques, and inspection accounting that will be used to implement of the inspection and accounting that will be used to implement in this chapter. See the audit, reconciliation, lease accounts, contracts, certified public accountants, availability, books, account records, and etc. necessary for audit. Secretary shall audit, reconcile with the extent practicable all current and past lease accounts of leases of the oil, gas, take appropriate action to make an additional collection refunds warranted. Secretary shall conduct audits, reconciliation, lease accounts, confirmation, business attractive to the record, keeping system where required of lease and secretary for a period covered by the audit. Secretary shall give priority auditing those lease accounts identified as state Indian tribe have significant potential for underpayment. The secretary may also audit the accounts and records selected by the leasers and operators. Secretary may enter for the contracts appropriate agreements with the independent certified public accountants, undertake audits and account records for any leaser operator relating to the lease and oil and gas. Selection of such independent certified public accountants shall be competitive bidding in accordance with Chapter 1, 2, Title 11 of Title 40, Division C, except Section 3302, 3307E, 3501B, 3509, 3906, 4710, 4711, and Subtitle 1 of Title 41, except the Secretary may enter for the contract other arrangement with an independent certified public accountant to audit any leaser, operator which such leaser and operator is primarily audit client of such certified public accountant. All books, accounts, financial records, reports, files, other papers of the Secretary or used by the Secretary were reasonably necessary to facilitate the audit required under this section shall be made available to any person, government, entity, conducting audits under this chapter. 1712, duties and leasers and operators of motor vehicle transport, liability and royalty payments. In order to increase receipts, achieve effective collections of the royalty, other payments, the leaser who is required to make a royalty and other payment under the lease, under mineral leasing laws, shall make such payments in a timely manner may be specified by the Secretary applicable delegated to the state. A leaser may designate a person to make all or part of the payments under the lease on the leaser's behalf and shall notify the Secretary applicable delegated to the state in writing of such designation. In event such a designated person may, in its own name, pay, offset, credit monies, make adjustments, requests, receive funds, submit reports, respect payments required by the leaser, notwithstanding any provisions in the chapter to the contrary of the designee, shall not be liable for any payment by obligation under the lease. The person owning the operating rating in the lease rights in the lease shall primarily liable for the prorate share of the payment obligations under the lease if the person owning the legal recorded title of in on a lease other than the operating rights owner of the person owning the legal record shall be secondary liable for the prorate share of the such obligation under the lease. Develop the compliance of security site security plan, minimum site security measurements, and operator notification security of well production. Operators shall develop and comply with the site security plan designating of the protected oil gas produced, stored on an offshore lease site from theft, which plan conform with the type of the minimum standard. Secretary may prescribe the rule taking into account various circumstances of the lease site. Develop compliance such minimum site security measures, measures as the security deems appropriate to protect the oil gas produced or stored on a lease site or on the outer continental shelf from theft. No later than the 5th business day after any well begins production anywhere, lease site or allocated to a lease site or resumes production in the case of the well which has been all production for more than 90 days, notify the Secretary in a manner prescribed by the Secretary on the date at which such production has begun or resumed. See possession, documentation, transport, oil, gas, motor vehicle, or pipeline. Any person engaged transporting motor vehicle oil from any lease site allocated to any such lease site shall carry out on his person and his vehicle or in his immediate control documentation showing at the minimum amount origin intended for the first destination of the oil. Any person engaged in transportation of oil and gas by the pipeline from any lease site allocated to any lease site for federal Indian lands shall be maintained documentation showing a minimum amount origin intended first destination such oils. 713, required record keeping. Maintenance available the record reports for information for the inspection duplication. Leaser, operator, or the other person directed involved with developing, producing, transport, purchasing, selling oil, gas, subject for the chapter throughout the point of first sale or the point of royalty computation, whichever is later shall be established, maintain any records, maintain any reports, provide any information Secretary may by rule reasonably require the purpose of the implementation chapter determine compliant with the rules orders under this chapter upon request any of the officers employed duly designated by the Secretary any state of the Indian tribe conduction audit investigation pursuant to the chapter appropriate records report information which were required in the section shall be made available to the inspection duplication by such officers employee state or Indian tribe. B. Length of time maintenance required record is required by the Secretary shall respect the oil gas leases from federal Indian lands and outer continental shelves shall maintain for 6 years after the records are generated unless the Secretary notified of the record holder has initiated audit investigation involving such records that such records must be maintained for a longer period in case the audit investigation is underway and records shall be maintained until the Secretary release of the record holder over the obligation to maintain such records. Alright, 1714, deposit royalty funds to Indian accounts. Deposit royalty funds derived from the production of oil, gas allocated to Indian land shall be made to the Secretary appropriate Indian account yearly practicable date for the such funds received by Secretary, but not in the case later than the last business day of the month and such funds are received. 715. Explanation of payments, description, period, source, and payments of state and Indians. When a payment is included, amount of the due, the receipt of any royalty, bonus, interest, charge, fine, or rental is made with the United States or to a state with respect to any oil, gas lease on the federal lands or deposited in the appropriate Indian account on behalf of the Indian tribe or the Indian allotter. With respect to any oil and gas leases on the Indian lands, there should be provided together with such a payment, the description, type of the payment being made, period covered by such payment, the source of the payment, the production amount of the royalty rate, the unit value, such other information is made agreed upon by the Secretary of the recipient state, Indian tribe, Indian allotter. Effective date section shall take effect with respect to the payments made after October 1st, 1983, unless Secretary by the rule prescribes early effective date. Or 1716, liabilities bonding. A person, including any agent employed with the United States with an independent contractor authorized to collect the receipt of the account, otherwise handle the monies payable for the receipt of the Department of Interior, which are derived with the sales and leave the other disposal with any oil, gas, should be liable to the United States for losses caused by any intentional, reckless action or inaction such individual with respect to such money, indicate that the independent contractor requires Secretary deems necessary to maintain a bond commensurate with the amount of money which sold such individual could be liable for the United States. 1717, hearings, investigation, authorization, affidavit of oath, subpoenas, testimony, and payments for the witness, and carry out his duties under this chapter. Secretary may conduct with the investigation of the inquiry necessary, appropriate, may conduct with the after notes of any hearing, audit necessary, appropriate to carry out his duties under this chapter in connection with such hearings, hearing, inquiry, investigation, audit with the Secretary also authorized, responsible, necessary. 1. To required by special or general order any person submit a writing and such affidavit to answer for the question the Secretary reasonable prescribed with the submission shall be made with a reasonable period but under an oath authorizes may be necessary administrative oath that requires some attendance of the testimony witness and production all paper books papers and production financial regular documentation matter materials and the Secretary may request for an order testimony to make the deposition before any person designated the Secretary who has the authority to administrate oaths and to comply with the testimony production evidence of the same manner is authorized under paragraph 3 of subsection 5. Pay the witness the same fee and mileage are paid to like circumstances in the court of the United States. Refusal to obey a subpoena. In case of the refusal to obey a subpoena served upon any person in the section district court of the United States, any district in which such person fund resides, transacts business upon application of the Attorney General or the request of the Secretary. After notice, such person shall have jurisdiction to issue an order requiring such a person to appear, give testimony before the Secretary, or to appear, produce documents before the Secretary. Any failure to obey such order of the court may be punished by such court as contempt thereof and subject to a penalty of $10,000 a day. 1718, inspection. Motor vehicles on lease sites, vehicles not on lease sites. On any lease site of the federal Indian lands authorized, properly identified, the representative of the Secretary may stop and inspect motor vehicle that has probable cause to believe carrying oil and lease on any federal Indian sites land allocated to such lease sites proposed with the determination of the driver or such vehicle documented to release such oil as required by law. Any authorized, properly identified representative of the Secretary accompanied by appropriate law enforcement officer for the appropriate law enforcement officer alone may stop and inspect the motor vehicle which is not on lease site if he is probable cause to believe that the vehicle is carrying oil from a lease site of the federal Indian lands allocated to such lease site. Such inspection should be for the purpose of determining whether the driver of such vehicle has documented required by law. Or B, inspection lease site with compliance with the mineral leasing laws in chapter. Authorized, properly identified representative of the Secretary may without an advance notice enter upon travel across and inspect lease site of federal lands, Indian lands, may obtain with the operator immediate access to the secured facility on such lease sites for purpose of making inspection investigation for determination whether there's compliance requirement of mineral leasing laws of the chapter. Secretary shall develop guidelines setting forth the coverage and frequency of such inspections. Rights the Secretary enter upon and travel across these sites for the purpose of making inspection investigation under this chapter. The Secretary shall have the same right enter upon travel across any lease or leaser operator is required to purchase, condemnation, or otherwise. 1719 Civil penalty. Failure to comply with the applicable law with the permit inspection of the notified secretary assignment exemption of the applicability of the penalty. Any person who, after due notice of violation, such a violation have the reported in subparagraph A failed to refuse to comply with any requirements, chapter A, mineral releasing law, any rule, regulation thereof that have the terms of any lease permitted issued thereunder, fails to permit inspection authorized in section 1718 with the title, fails to notify the secretary of the assignment under section 1712A2 with the title, shall be liable for the penalty up to $500 per violation each day such violation continues, taking from the date of such notice of the report. Penalty under subsection may not be applied to any of the person otherwise liable for the violation. Paragraph 1 of the violation is discovered, reported. The secretary has authorized representative liable the person corrected within 20 days after the report. Such longer time as the secretary may agree to or offer after the due notice for the violation is required in paragraph 1 has been given to such person by the secretary or authorized representative. Such person has corrected the violation within 20 days. Such notification or such longer time the secretary may agree to. B. Failure to corrective action. Corrective action is not taken within 40 days. The longer period the secretary may agree to after due notice of the reporter referred. Section A1. Such person may be liable to civil penalty not more than $5,000 per violation each day. Such violation continues dating from the date such notice reports. C. Failure to make a royalty payment. Failure to permit lawful entry, inspection, audit. Failure to notify security as well over the well production. Any person who knowingly, willfully fails to make a royalty payment with a date as specified by the statute, regulation, or the terms of the lease, fails to refuse permit, law, entry, inspection, audit, and knowingly, willfully refuses to comply with Section 1712B3 of the title, shall be liable for a penalty up to $10,000 per violation each day. Such violation continues. False information, unauthorized removal, etc., oil, gas purchases, sale, etc., stolen oil, gas, is knowing person. Any person knowingly, willfully prepares, maintains, submits false, inaccurate, misleading report, notice, affidavit, the records, data, other written information, knowingly, willfully takes or removes, transport, uses diverse oil, gas from lease site without having the valid legal authority to do so. 3. Purchase, accept, the sell, transport, conveys to another any oil, gas, knowing having the reason to know such oil, gas was stolen, unlawfully removed, diverted, shall be liable to the penalty up to $25,000 per violation for each day such violation continues. Hearing no penalty under this section be assessed until the person charged with the violation has been given the opportunity for a hearing on record. Deduction of the penalty from the sums owed to the United States. The amount of the penalty, any penalty under section finally determined, may be deducted from any sum owing by the United States of person in charge. G. Compromise reduction penalties on a case-by-case basis. The secretary may compromise reduce civil penalties under section H. Notice under this 3 subsection A shall be a personal service for the authorized representative secretary registered by registered mail. Any person may, in a manner prescribed by the secretary, designated representative, receive any notice under subsection I. Reason on record for amount penalty, and the determined amount of such penalty, whether it should be permitted to reduce and what amount. The secretary will state record reason for the determination. J. Review. Any person who is requested hearing according to the subsection E, with the time the secretary has prescribed for such hearing, who is aggrieved by final order of the secretary under the section, may seek for the review of such order for the United States District Court for judicial district, and when the violation allegedly took place, the review of the district court shall be only with the administrative record and note de novo. Such action shall be barred unless filed against 90 days after the secretary final order. K. Failure to pay the penalty. Any person that fails to pay the assessment civil penalty on this chapter after the order making an assessment has become final order, and such person does not file a petition for the judicial review in accordance with the subsection J. After the court action brought up against subsection J has entered final judgment in favor of the secretary, the court shall have jurisdiction to award amount assessed plus interest from the date of expiration 90-day period referred to in subsection J. Judgment by the court shall include in order to pay. L. Non-liability lease automatically terminated. No person shall be liable for a civil penalty under subsection A and B for failure to pay any rental for any lease automatically terminated pursuant to section 188 of this title. Section 1720, criminal penalties. Any person who commits an act for a civil penalty which a civil penalty is provided in Section 1719D of the title shall, upon conviction, be punished fine no more than $50,000 or imprisoned no more than 2 years or both. Section 1720, applicability civil and criminal penalties, various uses of federal Indian lands, outer continental shelf. Notwithstanding any of the provisions of the law, Section 1719, 1720 of the title shall, official year of the 2010, each official year thereafter, apply to lease authorization, exploration, development of coal, any other solid material, or geothermal resource of the federal Indian lands for any lease or easement, right of way, other agreement, regardless of the form of the use of the outer continental shelf, any of the resources under Section 1337K and 1337P, Title 43, same extent in such leases, easement, right of way, other agreement, regardless of the form, were an oil or gas lease, except in such cases the term royalty payment should include any payment required by such lease, easement, right of way, other agreement, regardless of form, application, regulation. 1721, royalty terms, condition, interest, and penalties. Charge any loyalty repayment, royalty payment deficiency. In the case of oil and gas lease, if the royalty payments do not receive the secretary on the date on which some of the payments are due or are less than the amount due, the secretary shall charge interest on such late payments or underpayments the rate applicable to under Section 6621, Title 26. In the case of underpayment, partial payment, interest shall be computed the charge on a month on the amount of the deficiency, not on the total amount due. Charges on late payment made with the Secretary of State. Any payment made with the Secretary of State under Section 191 of the title, any part of the payment made under Section Secretary of State from any oil gas royalty received by the Secretary which is not paid with the date required under Section 191 title shall include the interest charge computed on the rate applicable under Section 6621 in Title 26. C. Deposit royalty account charges royalties due owning Indians. All interest charged and collected under this chapter under applicable laws are because of the non-payment, late payment, underpayment of royalties due owning an Indian tribe or Indian allotter shall be deposited to the same account with the royalty with respect to which the such interest is paid. D. Charge on late deposit royalty fee fund Indian account. Deposit royalty funds may be the Secretary Indian account which is not made with the date required under Section 1714. The title shall include interest charge computed with the rate applicable under Section 6621 of Title 26, non-liability state secretary failure to comply with the Emergency Petroleum Allocation Act of 1973 or with regulations with thereunder, notwithstanding the provision law of no state with the assessment of the interest penalties found due against the secretary to failure to comply with the Emergency Petroleum Allocation Act of 1973, regulations secretary of energy thereunder concerning crude oil certification pricing in respect of the crude oil taken by security and secretary in kind as a royalty. Any state that shall under overcharge resulting in such failure to comply shall be assessed against the money found to be due with the owing such state with the result of its rolling account. Royalty accounts for transaction which took place in January 12, 1983. Exempt that there are completion such audit sufficient monies have been not found due to owing any state statute. Any state or the state shall be assessed for the balance for the state's share of the overcharge. Limitation of interest charge. The interest shall be charged under the section only for the number of days payment is late. Omitted. G. H. Estimated payment. At least over the designated may make with the payment the approximate amount of the royalties here in subsection estimated payment that would otherwise be due with the such lease of the day of the royalties are due with the lease when an event estimated payment is made. Actual royalties paid at the end of the month following the month in which the estimated payment is made. If the estimated payment was less than the amount actual royalties due, interest on the underpayment amount. If leasers and designee make the payment for such actual royalties, the leaser and the designee may apply estimated payment to the future royalties. Estimated payment to be adjusted and recouped and reinstated at any time by the leaser or its designee. Volume allocation of oil and gas production, except that otherwise provided in subsection a leaser designee of a lease of the unit commutation agreement with the same federal leases with the same royalty rate. Funds distribution shall report payroll to the oil gas for production over each production month based on the actual volume production sold by on behalf of the leaser. If the leaser or designated leaser in any other communization agreement shall report pay royalties on oil gas production for each production month based for the volume of oil gas produced from such an agreement allocated with the lease according to the terms of the agreement. Leases and designees for the lease not contained in the unit communalization agreement shall report pay royalties of oil gas production for each production month based on the actual volume of the production sold or behalf on the leaser. 2. The subsection applies only with the requirements of reporting paying royalties not within the subsection. And the subsection is intent with the alter of the leaser's liability with the royalties oil gas production based on share production allocated to the lease according to the terms of the lease, unit communization agreement, any other agreement. For any of the unit of the communization agreement, the leaser contractually agree with the alternative method of royalty reporting payment. The leaser may submit with the alternative method if the Secretary of the designated state for approval to make payment is in accordance with such approved alternative method so long as such alternative method does not reduce the amount of royalty obligation. Secretary of the delegated state shall grant the exemption of the reporting payment requirements for the marginal properties by allowing calendar year for any calendar year portion of thereof royalties to be paid each month based on the volume of production sold. Interest shall not accrue from the difference of the entire calendar year portion thereof between the amount of oil and gas actually sold and the share of the production and the share of production allocated to the lease until the beginning of the month following the such calendar year portion thereof. The additional royalties due, overpaid royalties, and associated interest paid with the refunded credits within 6 months after the end of each calendar year, in which royalties are based on the volume of the production sold for the purpose of the subsection term. Marginal property means lease that produces the average combined equivalent or less than 15 barrels of oil per well per day or 90,000 cubic feet of gas well per day. Combination thereof that determine dividing the average of the daily production crude oil natural gas producing well on such least number of such wells unless Secretary together with the state concerned determine the different production is more appropriate. Note that in 2 years after the August 13th, 1996, Secretary shall issue appropriate demand for all of the outstanding royalty payment due to this disputes regarding who's required to report and pay royalties on the production of the units and communization agreements outstanding on August 13, 1996, collecting royalties owed such production. Production allocation. Secretary shall issue determination, allocation, production, units, communication agreement is within 124 days request of the determination. Secretary failed to use the issue of the determination when it is such 120-day period. Secretary shall waive the interest due to the obligation such determination until the end of the month following the month when the determination is made. Alright, 1721 adjustment refund of the adjustment over the royalties to the second designee of the state with the during with the adjustment period of the lease for the designee with the determine the adjustment with the refund with the request of necessary to correct underpayment or overpayment of the obligation to leave for the designee shall make such adjustment request for the refund with a reasonable period of time only during the adjustment period following of the royalty report reflects underpayment or overpayment of the obligation shall constitute with the prior written notice for the secretary of the applicable delegate with the state of an adjustment for an adjustment of the lease of the designee shall calculate report interest due with the attributed with the adjustment at the same time lease of the designee or adjust the principal amount with such obligation exempt as provided in subparagraph B. In this case, the lease from the designee determined that subparagraph A would impose a hardship. The secretary shall delegate to the state that shall calculate the interest due with the notify of the lease for the designee within a reasonable time of the amount of interest due, unless such the leaser and designee elects to calculate report interest in accordance with subparagraph A. Any adjustment request the refund of the obligation may be moved to the adjustment period only upon the written notice appproval of the secretary applicable to delegated state approval as appropriate during the audit with the period included the production month of the adjustment being made with the overpayment identified during the audit. Secretary applicable delegated state with appropriate shall allow for the credit and refund of the amount of the overpayment for the purpose of this section adjustment period for any obligation shall be 6 years of the period following the date of the obligation become due for the adjustment period supersede with the total extended and enlarged terminated by some action limitation period in section 1724 of this title. B. Refunds. In general, request for a refund sufficient is made written to the Secretary for the purpose of section 1724 of the title specifically identified as a demand. B. Identify the person entitled to such refund. C. Provide Secretary information reasonable enough to enable Secretary to identify overpayment for which the sum refund is sought. Provides a reason for the payment that was an overpayment. Payment by Secretary of the Treasury. Secretary shall certify that the amount of the refund paid under paragraph 1. Secretary of the Treasury shall make such refund. Such refund shall be paid from the amounts received under current receipts from the sales bonus royalties, including interest charge collected under selection, rentals of the public land, Outer Continental Shelf under provision, Mineral Leasing Act, and Outer Continental Shelf Lands Act, which are not payable to the state or the reclamation fund. Portion of such refund attributed with any of the amounts previously dispersed state and reclamation fund or any of the recipient prescribed by law shall be deducted next disbursement, and so if the recipient made under applicable law such amounts deducted subsequent disbursement shall be created to the miscellaneous report receipts of the Treasury. 3. The payment period. Refund under subsection shall be paid with an explanation refund within 120 days of the request of the refund required received by the Secretary shall refund. Such refund shall be subject to the later audit by the Secretary applicable to the delegated state subject to the provisions of this chapter. 4. Prohibition against reduction of refunds of the credit. In no event shall the Secretary of any delegated state directly or indirectly claim, offset any amount or amounts against or reduce any refund or credit interest accrued thereon by the amount of any obligation that enforcement which is barred by section 724 of this title. 722. Injunction specific enforcement authority. In addition to any other remedy within this chapter of the mineral leasing laws, the Attorney General of the United States or his designee may bring civil action in district court of the United States. Shall have the jurisdiction over such action, restrain the violation of this chapter, comply with the taking the action required by under this chapter of mineral leasing law of the United States. Revenue of civil action described in subsection A may be brought on only within the United States District Court of the Judicial District where an act, omission, transaction, contribution, stating violation under this chapter or any other mineral leasing law occurred wherein defendants found transact business. 1723. Rewards. Where amounts represent royalty and other payments owed to the United States and with respect to oil and gas leases in federal lands, Outer Continental Shelf, required pursuant to take action by the Secretary or in this chapter result information provided to the Secretary by any person Secretary authorized to pay such person an amount equal to not more than 10% of the such recovered amount. These preceding sentences shall not apply with the information provided by an officer employee of the United States, officer or employee of the state, or Indian tribe acting pursuant to the cooperative agreement delegation under this chapter, or any person acting pursuant to the contract authorized by this chapter. Or 1724, Secretarial Delegated State Action Limitation Period. In general, the respective duties and responsibility activity of respective lease shall be performed in Secretary Delegated State Leasers designees timely manner, limited period, limitation period in general, judicial proceeding demanding of the right of the way. The obligation shall be commenced within 7 years of the day of the obligation becomes due, but not commenced, but shall be barred if the commencement judicial proceeding demand the obligation barred. But the Secretary Delegated State Leaser of the designee A shall not take any other further action regarding the obligation, including but not limited to the issuance of an annual order, request, demand, other communications seeking aid with the document accounting, termination, calculation, recalculation, payment principal, the interest assessment, penalty with the initiation, pursuant completion of the audit with respect to the obligation. B shall not pursue with any other equitable, legally remedied, whether under statute, common law, with respect to action of any enforcement of the said obligation. 2. Rules of construction. Judicial proceeding of the demand timely commenced on paragraph 1 against the designee shall be considered of the timely commenced to the leaser who is liable pursuant to section 1712A of the title for the obligation of the subject judicial proceeding or demand. Alright, 3. Application certain limitations set forth in 2401, 2415, 2416, 2416, Title 28, Section 22.6-2. But the title shall not be applied with the obligation chapters applied. Sections 37 and 16 of the Title 31 may be applied to the obligation of the enforcement, which is not barred by the chapter, may not be applied with the obligation of the enforcement, which is barred in this chapter. Obligation becomes due in general with the purpose of the chapter for the obligation becomes due with the right to enforcement obligation fixed. The royalty obligation rights to ensure any royalty obligation given the production month of the lease for the fixed purposes of the chapter latest day of the calendar month following with the month in oil gas is produced. Tolling and limitation period. The running and limitation period under subsection B shall not suspend, toll, extend, and enlarge for any obligation for any reason by action, including action Secretary delegated state other than the following: tolling agreement. A written agreement executed during the limitation period between the Secretary delegated state and the leaser and designee. Notice for the leaser shall designate with the designee shall toll the limitation period over the amount of time during the agreement is in effect. Subpoena. The issue of subpoena with the leaser with the designee. Note for the leaser with the designee with the designee with the written notice constitute with the subpoena of the leaser in accordance with the provisions subparagraph B1 shall toll the limitation period with respect to the obligation subject subpoena with the only period beginning with the date with the leaser designee of the receipt of the subpoena ending of the date on which one the leaser with the designee produced the subpoena records of the subject or obligation. 2. Secretary delegated state receiving the written notice of the subpoena record with such subject obligation are not inconsistent and not in the leaser's or designee position or control. 3. Court has determined a final decision that such records are not required to produce whichever occurs first. B1, a subpoena for the purpose of the subsection requires the leaser and the designee to produce records necessary to determine the proper reporting payment of the obligation due to the Secretary made issue on Assistant Secretary of the Interior, Acting Secretary, Acting Assistant Secretary of the Interior, who is Scheduled C, employee, defined in Section 213, 3301, Title 5 Code of Federal Regulations. The Director, Acting Director, respective Bureau and agency may not delegate to any other person in the state that has delegated authority pursuant to Section 1735 of the title stating, acting through highest state officials have the ultimate authority over collecting royalties on lease of federal lands of the state, misuse such subpoenas, and may not delegate such authority to any other person. 2. A subpoena described in Clause 1 may only be issued against the leaser for the designee during the limitation period provided in Section only after the Secretary of the designated state has a written request for the records for the leaser for the designated related to obligation with its subject of the subpoena has determined that 1. The leaser for the designee has failed to respond with a reasonable period of time. Secretary of the applicable the delegated state with a written request such records necessary for an audit, investigation, or other inquiry made in accordance with Secretary such delegated state responsibility on this chapter. 2. The leaser and the designee has written denied Secretary applicable to delegated state written request producing such record. The leaser of the designee possession control necessary for the audit, investigation, or other inquiry made in accordance with Secretary such delegated state responsibility on this chapter. 3. Leaser and designee has unreasonable delay of producing responsible records necessary for the audit, investigation, or other inquiry made in accordance with Secretary of the applicable delegated state responsibilities on a chapter after Secretary and delegated state written requests. And seeking records, Secretary applicable delegated state shall afford to the leaser designee a reasonable period of time written request Secretary such delegated state within which provide such records prior to the issuance of the subpoena. 3. Misrepresentation, concealment. An initial misrepresentation or concealment of the material fact purpose of evading of the payment of the obligation, which case of the limitation period shall be told for the period of such misrepresentation, such concealment. 4. Order to perform restructured accounting. The issue for the notice of the subparagraph D of the lease for the designee has not substantially complied with the requirement to perform restructured accounting shall toll for the limitation period with respect to the application with subject with the notice of the only with the period beginning with the date of the lease for the designee receiving the notice ending 120 days after the date on which 1. The Secretary is applicable to the delegated state with the receipt of the written notice of the accounting other requirement has been performed, or 2. Court has determined the final decision on the lease of the required for the perform accounting whichever occurs first. If the lease for the designee initiated the administrative appeal, judicial proceeding concepts and order for the perform restructured account, the issue in subparagraph B1 limitation period subsection B shall be told for the date of the lease for the designee received an order for the final and non-appealable decision issued for any such proceeding. B1 Secretary applicable to the delegated state may issue an order to perform restructured accounting lease for the designee of the Secretary shall delegated state determines during an audit or lease shall be delegated with the state of the finding of the lease for the designee has been identified underpayment or overpayments which are demonstrated by the Secretary delegated with the state to be based upon repeated systematic reporting error with a significant number of leases or a single lease for a significant number of reporting months with the same type of the error which constitute a pattern violations which are likely to result in significant underpayment and overpayments. 2. The power of the Secretary to issue an order and to perform restructured accounting may not be delegated below the most senior career professional's position having responsibility for royalty management program, which position is currently designated Associate Director of the Royalty Management, may not be delegated to any other person state that has been delegated authority pursuant to Section 1735 of the Title State acting through the highest ranking state official have the ultimate authority over the collection of royalties from the lease on the federal lands within the state, may issue such orders of the perform which may be not delegated to any of the person in order to perform a restructured account shall 1. Be issued reasonable period of time with the audit identify systematic reporting errors. 2. Specify the reason with factual basis of such order. 3. Be specified identified with the order to perform restructured accounting. 4. Provide leaser designate a reasonable period of time, not less than 60 days, in which the day to perform restructured accounting. 5. Provide leaser designate 60 days in with which the file of administrative appeal to the order of the perform restructured accounting. C. Any order to perform restructured accounting shall not mean or be construed to include any other action by or behalf of the Secretary of Delegated State. If the leaser designee fails to substantially comply with the requirement to perform restructured accounting pursuant to the subsection, notice that shall be issued to the leaser. The designee of the leaser is the designee having substantially complied with the requirement to perform restructured accounting. Leaser and his designee shall be given the reasonable time in which for the performance of the restructured accounting. Such notice may be issued under subsection only by the Assistant Secretary of the Interior or Acting Secretary of the Interior, whose Schedule C employee is defined in Section 213-3301 Title 5 Code of Regulation may not be delegated to any other person. If the state has delegated authority pursuant to Section 1735 of the title state with the acting with the highest state official, having the ultimate authority of the collection royalties of the leases in federal lands, the state may issue the type of notice which may be delegated to any other person. E. Termination limitation period. Action and enforcement obligation. Secretary delegated state of the lease for the designee shall be bared under the section prior to running of the 7-year-old period prior to the section B of the event. When secretary delegated has notified the leaser designee writing of the time period closed with the further audit, the secretary delegated state leaser designee has agreed in writing for the purpose of subsection of the agreement of the designee shall be binding, or any leaser who is liable pursuant to section 1712A with the title of the obligation are subject to the notice agreement. F. Records required to determine collections. Records required pursuant to Section 713 of the title secretary or delegated state for the purpose of determining obligation due to complying with the applicable mineral leasing and leasing provisions regulation with the order to respect with the oil and gas lease of the federal lands outer continental shelf shall be maintained for the same period of time during the judicial proceedings. The demand with the may be to commence with under subsection. And B. If the judicial proceeding with the demand is timely commenced with the record holder shall maintain such the records and finally not an applicable decision in such judicial proceedings is made with respect to the demand rendering unless the secretary is applicable to delegated state authorities in writing earlier release requirement to maintain such records, notwithstanding any of the here, there, and there contrary, under no circumstances shall the release record holder be required to maintain produce record relating to the obligation for the time period barred with the application limitation selection connection any hearing administrative proceeding any inquiry investigation audit by the secretary delegated state on this chapter. Secretary delegated state shall minimize the submission multiple redundant information, make good faith effort, locate records previously submitted by the leaser or designee of the secretary delegated state prior to requiring the leaser designate provide such records. RG timely connection. Order mostly effectively utilize resources available to the secretary maximize the collection of the oil and gas receipts of the lease of obligation to the treasurer within 70 years period of limitation. Consequently, maximize the state share of such receipt. Secretary shall not perform the requiring accounting reporting audit activity. The secretary of state with the concern determining the cost conducting requiring the activity exceed the expected amount to be collected activity based on the month's currently 12 months activity. This subsection shall not provide a defense to a demand and order to perform restructured accounting to the maximum extent possible. Secretary delegated states shall reduce costs. United States Treasury states by the discounting requirements unnecessary to duplicate the data, other information, such separate allowances, payee information relating to the obligation due. Secretary and state consider the determination collection results soon. Secretary applicable to delegated state may waive, forego interest in whole and part. H. Appeals and final agency, 33-month period. Demands or orders issued by the Secretary of the Delegated State are subject to administrative appeal in accordance with the regulation of the Secretary of the no state shall impose any condition which hinder the leasers or designees immediate appeal of an order to the Secretary or Secretary's designee. Secretary shall issue the final decision in any administrative proceeding, including administrative proceeding pending August 13, 1996, within 33 months for the day of the proceeding commenced, 33 months from August 13th, 1996, whichever is later. The 33-month period may extend by period of time agreed upon in writing and the Secretary appealing it. To effective failure in issue decision. No such decision has been issued, Secretary, within 33-month period referred in paragraph 1. Secretary shall deem the have issued granted decision in favor of the appellant to as any non-monetary obligation or monetary obligation principal amount less than $10,000, and Secretary shall deem have issued final decision favored Secretary, which decision shall be deemed affirming those issues of the agency rendered decision prior to end, such as monetary obligation principal amount which is $10,000 or more. Applicant shall have the right to judicial review such deemed final and initial decision in accordance with Title V. Collection disputed amounts due. To expedite collection relating to the disputed obligation due within a 7-year period prior to the day of the obligation become due, parties shall hold with not less than one settlement conciliation. Secretary state with a concern to make such action appropriately compromise settle the disputed obligation, include waiving and reducing interest, allowing offsetting obligation among leases. J. Enforcement claim judicial review in the event of a demand subject to the section properly timely commence the obligation which demands may be enforced beyond 7-year limitation period without being barred by statute of limitation. In the event the demand subject to the section properly timely commence the judicial proceeding of the challenge of final agency with respect to such demand shall be deemed timely so long as the judicial proceeding is commenced within 100 days after from the receipt of the notice of the lease or designee of the final agency action. K. Implementation final decision. If any judicial proceeding with demand subject to the section and the timely commence thereafter, limitation period section lapse during the pendency such proceeding, any part such producing such shall not be barred with taking such action required necessary to implement final unapplicable judicial administrative decision, including any action required necessary to implement such decision by recovery, recoupment of an underpayment, overpayment may be refunded of credit. Alright, L. Statement of obligation from pending review. Any person ordered by the Secretary delegated state pay the obligation other than the assessment shall be entitled to take such payment of the surety instrument pending on administrative judicial proceeding and personally periodically demonstrated satisfaction Secretary that such person is financially solvent otherwise will be able to pay obligation. In this event, the person is not able to do so. Demonstrated the Secretary may require a bond other surety instrument satisfaction to cover the obligation. Any person ordered to the Secretary they are delegated to pay the assessment shall be entitled to stay without bond or other surety instrument. Alright, 1725 assessment beginning in the 18th month after August 13, 1996, encourage proper royalty payments for the Secretary or the delegated state shall impose the assessment on a person chronically submitted with the earnest reports on the chapter. The assessment under this chapter may only be issued provided for this section. 1726. Alternative marginal property. Determination best interest states concerned with the United States. Secretary and state concerned with acting in the best interest of the United States. States concerned promote production, reduct the administrative cost of the increased net received of the United States and the states shall jointly determine in case-by-case basis the amount of the marginal production of the lease or leases or wells or parts thereof subject to the prepayment under subsection B, regulatory relief in subsection C. If the state is concerned does not consent with the repayment, regulatory relief shall not be made under this section of the marginal production, provided that the royalty payments from the lease or leases or wells are not shared when they state. Such determination shall be made solely by the Secretary. Payment of royalty. In general, notwithstanding provisional relief of the contract of the lease or leases of the wells or wells identified with the Secretary of State with the concern pursuant in subsection A, Secretary authorized to accept the prepayment of the royalties in lieu of the monthly of the royalty payment, the term of the lease, remainder of the lease, term and effect of the leases, the leaser so agrees. A prepayment agreed for the Secretary of State with the concern of the leaser, which is less than any of the average $500 per month. The total royalties should be effectuated under section no earlier than 2 years after the August 13, 1996. Any prepayment which is greater than $500 per month, the total royalties shall be effectuated under section no earlier than 3 years after August 13, 1996. Secretary and State concerned with make condition acceptance prepayment authorized under section of the leasers agreeing such term and a condition. Secretary of State concerned with the deemed appropriately consistent with the purpose of this chapter. Such terms may A. Provide prepayment that does not result in the loss or revenue of the United States in present value terms. B. Include provision of receiving additional prepayment of royalty developments and lease or leases or wells deviate significantly the assumption fact of the valuation is determined. And C. Require leasers or designees to provide such periodic production reports as may be necessary to allow Secretary and the state concerned with the monitor production purposes of subparagraph B. 2. A state share of prepayment under the section shall be shared by the Secretary with any state other recipient the same extent as any royalty payment for such lease. Satisfaction obligation except to provide with the terms and conditions established Secretary under subsection B. The release of the designee who makes prepayment payment under this section will be satisfied with the whole lease or obligation to pay the royalty on the production stream sold from lease or leasers or wells. Alternative accounting audit requirements. Within 1 year after August 1st, 1996, Secretary of the Delegate shall provide with accounting, reporting, auditing, relief of the incurred leasers. Continue to produce the developed property with the subsection A to provide such relief that available to leasers within the state that concurs, which concurrence is not required for the royalty payment to lease of the leasers. Wells not shared with any state with the prior to granting such relief of the Secretary, if the appropriate state concerned shall agree with the type of the marginal well with the relief provided under this paragraph, best interest of the United States, if appropriate and concerned. Alright, 1727, the royalties on all extracted methane in general for all these issued after August 16, 2022, except for the provided subsection B, royalties paid for the gas produced from federal land on outer continental shelves will be accepted on all gas produced, including all gas that is consumed lost by venting, flaring, negligent release through any of the equipment during upstream operation. Exemption. Subsection A shall not apply with respect to gas vented flared no longer than 48 hours in an emergency situation that poses danger to human health and safety of the environment. Gas used and consumed within the area of the lease unit communitized area for the benefit of the leasing unit communitized area, and gases are unavoidably lost. Subchapter 2, State and Indian Tribes. And we're going to cut the tape there.